Thank you, Amy. And thank you everyone for coming here to this Bargaining 101. It's just sort of an explanation of what goes on behind the scenes of negotiating a contract at Oakland. My name is Michael Latcha. I'm an associate professor in engineering. I was a bargaining team member in 94, 97, and in 2000. And I was fortunate enough to be the chief negotiator 2006 through 2015. The right to form unions and the right to bargain collectively was established in the United States in 1935 with the National Labor Relations Act, which I will refer to as we go through here as the NLRA. The right for public employees to form unions and bargain collectively was established in Michigan with the Michigan Public Employment Relations Act of 1947, which has been, and both of them, of course, have been amended several times since then. I'm really not going to go through any when changes happened kind of discussions, really just going to concentrate on what the rules are at the current time as we're going to be moving through next summer. Choosing a bargaining team is very different between the two sides, Oakland and the AAUP. Choosing an AAUP bargaining team, the executive committee appoints a 3-person nominating committee from the executive committee, plus 2 more members from the general membership. Those people then go out and identify a chief negotiator, usually working with a list of people from previous chief negotiators, from people who have volunteered, members of former bargaining teams or previous bargaining teams, etc. Once they identify a chief negotiator, then the nominating committee and that chief negotiator identify a team of at least 5 members, which includes the executive director. They're looking for representation across the university. They typically are looking for people who have talents in certain areas, like for instance, to do financial analysis. That becomes very important when we get to talking about money, usually near the end of the summer. That nominated team then is presented to the membership at a general meeting. At those meetings, alternative teams may be nominated by the membership. And then the team is then ratified by the membership via a formal election. Oakland's team is chosen through a process that we're not entirely familiar with. It usually consists of at least 1 dean, members of the administration from academic affairs and finance. The chief negotiator is either an outside attorney or someone from the provost's office. Occasionally in the past, Oakland has had co-chief negotiators, one an outside attorney and someone from the provost's office. The exact process of how their team is rounded out is largely unknown. However, as I've talked to various people on administrative teams, it seems to boil down to people who are asked to be on the team and the people that do not have sufficient reasons not to end up being on the team. There's always someone there from, however, academic affairs and someone there from finance. One of the questions that always comes up is, why don't we hire outside lawyers to bargain? And there are some pros to that. That is to let the professionals handle labor negotiations. There are a lot of rules that you can run afoul of quite inadvertently if you're not familiar with them as we go through this process. Not having an emotional attachment to issues sometimes makes it easier to bargain. There are also cons that go along with that. It is difficult and time consuming. And when we're talking about attorneys, that we're talking about expensive. Getting outside agents up to speed on issues, why those issues are important, which ones we're willing to to bend on, which ones we absolutely cannot backtrack on. Another con of letting an outside agent, such as an attorney, bargain for you is that person usually does not have to administer or live under the agreement. So they will tend to try to make decisions or move in a particular direction, knowing that all they have to do is get an agreement and they're off doing something else. They don't have to necessarily be constrained to that agreement that they agreed to. Other cons for having an attorney at the table is it tends to raise the anxiety level on both sides of the table. When you have outside attorneys bargaining for you. And for that reason, most of the time, we have chosen to keep attorneys. We have chosen to keep attorneys in the background, in reserve, certainly always on speed dial, but not necessarily on point. In terms of preparing for bargaining, there are several steps that we go through. One of them, and one of the most important ones, is what are called information requests. The National Labor Relations Act requires employees to furnish to unions information that's relevant to the administration or negotiation of a collective bargaining agreement upon request. Interestingly enough, this ruling that was made in 1979 was in result of a lawsuit brought against Detroit Edison, who was sued because they were withholding information from their union. These information requests can be fairly far-ranging as long as you can relate it to information that we need to effectively bargain. They can be probative. That is, we can ask for information about an issue that we are just thinking about negotiating. And, depending on what sort of gamesmanship is going on, sometimes you ask for information about issues to give the other side, to give the administration an idea that you are going to bargain that, and to put them sort of in a mode of being concerned about that issue. As we go through this process, you're going to realize that there is some art to all of this, and it's not necessarily particularly a straightforward process. We also gather information from the advisory forum survey. This is a direct measurement of how the faculty feel about issues in the university currently and how they would like to change in the future. This is a very important piece of information that the bargaining team takes. Another very important event that occurs are the meetings with the academic units. This began with the 2000 bargaining team and has continued since. I have found this to be extraordinarily helpful, even though we get the same information typically when we meet with the academic units that we get from the advisory forum survey. It suddenly becomes much more real when you look into people's faces and they tell you that this is what we need. This is how we cannot live with this any longer. The bargaining team has been pouring through the agreement, looking for issues that need to be addressed next summer. They are also reviewing recent grievances and looking to see how the language in the agreement can be adjusted to avoid those kinds of things in the future. Even very minor issues like typos are very valuable at this point to identify, because it'll give the two teams easy things to agree on and to establish a rapport. as we move through the summer and having to deal with much more thorny issues. Again, it's a negotiation is a give and take between people, and being able to trust people and come to agreement is something that typically groups of people need practice with before they get good at it and have it to take on very important issues. Also, in preparing to bargain, we have to notify the state of Michigan of the intent that we have to bargain a new agreement. This will become important at the end game when if either side, for instance, feels the need to call in state mediators. When we notify the state of the intent to bargain, they notify their mediators that this contract is expiring on this date. Expect phone calls from these people if they need help reaching an agreement. Once we start meeting with the administration, typically one of the first things that is negotiated are ground rules and a schedule for meeting during that summer. And this is a very important first stage because it is the first kinds of issues that we get to agree on. Ground rules, for instance, is how are we going to exchange proposals? Are they going to be on paper or are they going to be electronic? If they're on paper, does that paper have holes in it or does it not have holes in it? If someone has conferences or vacations scheduled, then those times are blocked out during the summer. And again, this is a give and take between two groups of people. And as agreement is reached on even these tiny minor points, a rapport is being set up between the two teams, getting ready to bargain thorny issues. A typical bargaining session with the administration consists really of presenting or questioning proposals and presenting and questioning counter proposals. And it is that simple and that complicated. That is, our team will prepare proposals saying that this is an issue, this is what we want to see on that issue, and we would present that to the administration with typically with a verbal explanation. They would take that, listen, ask questions, go off, and if they felt
Mike, I muted you. Can you unmute for a second? I was trying to mute someone else.
That's okay.
Sorry.
Right. It's okay. So we would give a proposal to the administration. They would ask questions on it after our verbal explanation. If they thought that was an issue that was worth pursuing, they perhaps would prepare a counter proposal for the next bargaining session, or they could come back and ask more questions, or they could just simply come back and say no. Typically in the sessions, it's a discussion. It's typically not a debate. You are listening carefully for why the administration feels or the other side feels this way about this issue, what kinds of things they're looking for as an improvement to the language in the agreement concerning this issue. Rarely do you do things like score points. Rarely do you come up with some sort of an explanation or an answer to a question that completely changes the way they think about a particular issue. But it does happen. One that I remember very clearly was we were discussing changes to the review schedule. And those of you who are familiar with that, if CAP wants to go against the department recommendation, they are obliged to call in the department chair and get more information verbally during a meeting. And the administration wanted a record of that meeting. And during the discussion of it, we realized that in order to get to that meeting, we would have to essentially take a straw vote of cap. And if that meeting was recorded, then essentially we would be making public the result of a straw vote on a candidate's record. And straw votes are never made public. And because of that, the administration immediately dropped that proposal. So it happens, but it happens very rarely that during the discussion that people completely change the way they're thinking about a particular proposal. Typical bargaining about an issue is not necessarily a linear process, nor is particularly a rational process. Again, there are people that are negotiating, and depending on who is driving the issue, and it may be none of the people at the table are driving the issue. The people at the table are there just to argue the points of the people that are driving it. So, you know, how that discussion takes place is sometimes a little bizarre, but you sort of have to understand that the point of all of this is to get to an agreement at the end. And the little things that happen during any particular meeting, a lot of times you just have to let go of and move forward towards an agreement. So what kinds of issues can be bargained? The National Labor Relations Act identifies 3 types of subjects that are for bargaining. One are mandatory issues, then there are permissive or voluntary issues, and then there are illegal subjects. The Michigan Public Relations Act defines mandatory issues of bargaining for public employees as rates of pay, wages, hours of employment, or other conditions of employment. That is, compensation and working conditions. Anything that falls under those general headings must be bargained. And even if a union and an administration have an agreement, if something changes with compensation or working conditions, the law says that that must be bargained. It cannot be imposed unilaterally by the employer. An illegal subject would be anything that violates a law. So, for instance, we cannot have an agreement that, you know, some sort of provision where someone is kidnapped. But we can also not have an agreement, cannot have a provision in the agreement that violates any other law. For instance, Michigan as a public employer, Oakland as a public employer has the right to outsource services, even services that are performed by the faculty. And so we could not have a provision in our agreement that says that Oakland cannot outsource faculty work, because that would violate a law. However, if Oakland was going to outsource faculty work, they would have to bargain as a mandatory issue how that outsourcing would impact the faculty compensation and working conditions. A permissive area or subject of bargaining is anything that's not mandatory or illegal, as agreed to by both parties. So, and this agreed to by both parties ends up being very important, because you may want to talk about a subject that is permissive or permissible to bargain, but the other side may just simply refuse to bargain that. And at that point, that issue comes off the table. We have used this in the past, in the recent past. Oakland has come to us in the last couple of rounds of negotiation, wanting to take the chairs out of the bargaining unit. which is a permissive area of bargaining. Um, we just simply told Oakland that we were not interested in bargaining changes to the definition of the bargaining unit, and that was it. That was the end of that issue. Now, in terms of issues, who exactly decides what to bargain? Well, ultimately, that is the bargaining team. And that bargaining team takes input from the advisory forum survey, from academic unit meetings. They take clues from recent grievances and run-ins that faculty has had with Oakland. The team can identify issues on their own through their analysis and the critique of the current agreement. Our team is also, and previous teams also, interact closely with the AAUP National, the state conference, and other chapters in the state. When we had a much more active state conference, the chief negotiators that were bargaining in any particular summer would actually talk fairly frequently about issues that their administrations were bringing to them. And it was remarkable how many issues were essentially the same between, say, Oakland and Western and Northern Michigan universities. The administrations were bringing issues to us that were in some cases worded almost exactly the same. Oakland's issues come to them, we know for sure, from the Dean's Council, from the President's Cabinet, and most notably from the Board of Trustees. And typically we can tell which issues are coming from which area, but those are the main sources of issues that issues that Oakland brings to the table. And last but certainly not least is that sometimes there are issues that just simply pop up at the table as within the discussions of other proposals. And so the team needs to be very flexible in terms of issues as they develop, as they are identified. And sometimes during the summer itself, there are new issues that pop up that the team may feel need to be negotiated for the upcoming agreement. How much time does bargaining take? And the flippant answer is, of course, it takes as much time as it takes. But this changes considerably as we move through this entire process. Our team started preparing for bargaining last summer. During this fall and this winter semester before bargaining, it amounts to about a couple hours a week as they are meeting to pour through the agreement, to meet with people at the national and the state level, to look over and try to assimilate data from the advisory forums. In April, in this month, that's going to ramp up to several hours per week as we finish the winter semester and get ready for bargaining to actually begin in mid-May. Now is when people are going to start drafting proposals and getting ready for an initial flurry of activity when bargaining starts. Bargaining starts on May 15th, according to the agreement. So May through July, it may be several hours per day that the team spends working on bargaining. And that will ebb and flow, of course, during the summer. If our team, for instance, is next up in terms of presenting proposals or counter proposals, there will be several days of perhaps intense activity, followed by several days of waiting for Oakland to respond to things. So it's not several hours every day. It's several hours a few times a week. Once we hit August, however, through the time when the new agreement is settled, our team will be essentially eating, sleeping, and breathing nothing but bargaining. It is a fairly intense time. Some of us find it exciting. Others find it incredibly draining. In terms of bargaining tactics, and this is, as I've served on other teams and talked about bargaining with faculty, this is typically what they want to talk about, is that can we simply just demand what we want? And can we say no to anything the administration wants from us? And the question is, and the answer is, of course we can, and we do. When we give them a proposal, we are telling them exactly what we want. We're demanding that this be done. And a typical response to any initial proposal from the administration is no, we're not going to do that. And we do this for as long as we can, and that is until we can't. And the difficulty is that eventually negotiations have to make progress towards an agreement. We have to eventually avoid what's called an impasse and the consequences of an impasse. And I will talk about a definition of that in just a second. But eventually you have to start making progress towards an agreement. A negotiation is a give and take. And if there is no giving and taking, then the process stops. And the stopping of that process favors the administration. In the process of bargaining and in the process of negotiating any particular issue, there's, again, this is an interaction between people. And it's difficult to check your emotions and your feelings when you're talking about issues, especially issues that are very important to you. So the whole idea of bargaining in good faith or bargaining in bad faith often comes up. So, we're really down to a legal definition of what does this mean. Legally, bargaining in bad faith just simply boils down to, if you have a signed tentative agreement, to go back and say, no, we're not gonna honor that. That's really the only thing that you can do legally that is bargaining in bad faith. You've gone back on your word. Hard bargaining, that is taking a position and not budging from it, even retroactive negotiation, where you would say, we want a 5% raise, and Oakland agrees to it, and we come back and say, no, we want a 6% raise. That's considered retroactive negotiation. Legally, that's not bargaining in bad faith. That's just really hard bargaining. So it is, even though during the process of negotiation, your feelings may be hurt, and I am the first one to admit that sometimes across the table, you hear some really awful things that are said about faculty and how they work and their attitudes towards work and their attitudes towards administration. And some of them are very difficult to hear. But again, you have to always remind yourself that these are tactics that are used at the table to, sometimes they're used to simply get you upset so that you will do something to advantage the administration or advantage the other side. I'm not going to tell you that I have not resorted to such things myself, because I have, in order to make a point or in order to move some issue either off the table or towards some sort of an agreement. So the end game, when a lot of us become very aware of what's going on in negotiation, let's say August 14th, the day before the previous agreement expires. Who decides when to stop bargaining and to settle, and how? Well, eventually, the need for a new agreement becomes the most important thing. There are all sorts of legal consequences when a current agreement expires, and we'll talk about those in a second. And to avoid those things from happening, the goal is to have a tentative agreement on a new agreement before the old one expires. In order to help that, either side can call in state mediators to help reach an agreement. And a state mediator, when they show up, they are both helpful and they're both very annoying. State mediators do not take sides. They will listen to and analyze the last proposals that are on the table from both sides. And their job is to move both sides towards an agreement. So they're helpful in that they are, in our case, they're urging Oakland to move towards our position. And then they walk down the hall and meet with us, and they're urging us to move towards Oakland and reach an agreement. And sometimes sometimes you end up having to negotiate with the mediator and with Oakland. It can help in a lot of ways. It can hinder in fewer ways, but it is always there to move towards an agreement. When all the issues have been agreed to, or simply dropped, which is another way to agree to them, then both sides sign what's called a tentative agreement. The Oakland team must present the tentative agreement to the executive committee before formally agreeing and signing off on it with Oakland. And this is an important tactical thing that happens at the very end, where sometimes this happens at 2 or 3 o'clock in the morning, when it looks like everything has gelled and the two teams are either exhausted enough or satisfied enough to get a tentative agreement. At this point, the Oakland team, or I'm sorry, the AAUP team can say, well, timeout, we have to meet with our executive committee. And this is sort of a last reality check before we get a tentative agreement. The executive committee will assemble and will listen to the proposal that the team is intending on signing as a tentative agreement, and the executive committee will question, how did you get here? Why is this the best one that we can get? It's important to note that the executive committee does not get to turn down the tentative agreement, but the team has to present it to the executive committee first as sort of a reality check. Once it's signed with the administration, then that tentative agreement is explained to the membership in public meetings, and it's ratified by a secret ballot vote. And then after that, it is ratified and adopted by the board of trustees, and we have a new agreement. So what is an impasse, and what are its consequences? So an impasse occurs when both parties come to the realization that further negotiations would be pointless. That is, on every position, on every open issue that is still left on the table, neither side is willing to move. And they're firmly dug in. The mediators can have tried, but they can't move. And no one is willing to move on this at all. This is a fairly dangerous thing for a union to do. The National Labor Relations Act says that if negotiations reach an impasse, an employer can then impose their last best offer that was made to the union before impasse was reached. That is, if both sides agree that there is no more progress that's available in negotiations, the default, which has been upheld by courts, is that the administration, in our case, wins. Their last offer is what the new agreement is. This has the potential to be used as a tactic. It is a very risky tactic. And I will admit that I've been advised by state mediators to say that, oh, we're at an impasse, we'll just accept what Oakland's last offer is, and we will just we'll accept a new agreement that we don't like and try to deal with it from that. That's never been an acceptable tactic for me to use, but I can't speak to any sort of conditions in the future where that may not make sense. So what happens if the agreement isn't settled on in time? Michigan law says that wages and benefits continue as under the previous agreement, which means no raises if our agreement happened to line up with healthcare benefits, for instance, and the price of those benefits went up. The price of those benefits would be borne by the faculty, not by the administration. So nothing changes. Bargaining continues until either a settlement or an impasse is reached. During that time, between the end of the previous agreement and the time a settlement is reached, that the new agreement cannot contain any retroactive pay or increases in benefits for that time period between the time the previous agreement ended and the new one starts. And this is to try to force agreement to occur before the previous agreement has expired. And if this looks like it is in favor of the employer, you are absolutely correct. It is in favor of the employer. So the question is always, can we go on strike? And by the Public Relations Act, because we are public employees, the membership of the Oakland AAUP cannot strike. It is against the law for us to go on strike. However, we have occasionally had to resort to job actions to focus attention on getting an acceptable tentative agreement. The last time that we did this was in 2009. There are some fairly severe consequences to doing this. It is against the law, and we typically immediately end up in court, depending on the issues that are still left on the table and the behavior of both sides. Sometimes the judge that we're in front of will allow the process to continue before ordering the faculty back to work. That's what happened in 2009. We happened to be heading into the Labor Day weekend, and the judge we had was very union friendly, and he in fact stayed with us as we negotiated for nearly a week after classes were to begin. That was an enormously stressful week, and we were living under the threat that arrangement could end at any moment. So have we ever worked without a contract, or has the faculty ever turned down a tentative agreement? We have a long history of not working without a tentative agreement. However, we do know that going on strike is against the law. In the distant past, before my time at Oakland, I am told that the membership has in fact turned down tentative agreements. In the Oakland AAUP bylaws, it says that the executive committee shall have the option of either retaining or reconstituting the negotiating team if a tentative agreement is turned down. The negotiating team also has, at that point, the choice of whether they will accept a reconstituting or retaining of that negotiating team. If it's reconstituted, then we have to choose a negotiating team according to the bylaws. We have to form a nominating committee, form a slate. It has to be approved by the membership. And once that happens, then bargaining restarts, and it continues until an agreement or an impasse is reached. And at that point, since we are past the point where the previous agreement has ended, that new agreement cannot contain any retroactive increases in salary or any other compensation. Past experience, I'm told, has shown that in this, after a TA has been turned down, Oakland, in fact, does not change their last offer at all. Even after months of renewed bargaining. The story that I was told the last time this happened, the new agreement was not reached until the next April. And essentially because there was no movement at all during that time, essentially the faculty ended up having to accept the tentative agreement that was made the previous August. So with that, my presentation is done, and we can open this up to questions if you have any.
Thank you, Mike. That was awesome. Very helpful. So if you have a question, feel free to raise your hand or just shout out, or you can send me a direct message and I can ask Mike for you if you would prefer. There's a couple questions in the chat. I guess, I mean, so some of these questions, Mike probably won't speak directly to negotiations this summer, but do you want to offer any input on how you think the pandemic will impact negotiations? Or do you not want to touch that one?
Well, I'll start. No, I will only speak in general about anything here. The negotiations will take place, the bargaining sessions will take place virtually, which for me would be very difficult. I tend to spend most of my time during a bargaining session watching people's faces and trying to read body language. And the people that have been on teams with me know that this is very important, at least to me. And sometimes I assign people, other members of the administration team, to watch and to see what their reactions are as we're presenting proposals. That would be fairly difficult during virtually, because all someone would have to do is turn the camera off, and that's lost.
There was another question asked about what court do we end up in if there are court issues? Is it state or federal?
It's actually when we usually end up in court, it's at Oakland County Court. Those are the ones that, yes, it's an Oakland County Court.
Other questions, comments?
I guess I can ask one.
Go for it, Stefan.
Go ahead.
Okay. If there's an issue referring back to a previous agreement, would our tentative 1-year extension because of COVID factor in any way? Or is that something that, as far as negotiations are concerned, both sides have agreed that doesn't exist for the purpose of, we did this during the COVID year, so we want to. I thought we had agreed that wouldn't carry forward. So how will that?
It's again, this becomes very specific to these negotiations, so I am not going to speak specifically to that. All right. But it is possible, for instance, to when something like this happens, it is possible to codify what happened in that in, for instance, a letter of agreement that sits at the end of the agreement, the agreement itself. So you would essentially document this in the agreement, and it would stay there until those issues were not we weren't dealing with those issues anymore, which may be several years. Who knows?
Another question for you, Mike. How much of
Mhm.
bargaining time is wasted in the early summer?
I guess I'm not sure what you mean by wasted. If you mean by, taking positions and and acting like you're not going to move on those positions, that's not necessarily wasted time. Anytime you spend talking with the other side, you're spending that time getting to know how they are, how dedicated they are to a particular issue or position, and looking for signals of places where they can move in that. So even though you may spend a session or two or five or 10 not making much headway in terms of issues, if you're open to it, you are certainly learning how important those issues are to the other side, and where if you want to phrase it this way, where the soft spots are that you can poke at later on to get people to move in towards an agreement.
Another question for you. Since the impasse definitely favors the administration, why don't they just use hard bargaining from the start and just always use it?
They absolutely could. There are, however, there are many theories and techniques to negotiating, that if you do this often enough, you start to study these things and look into them. All of them, however, agree that it is absolutely possible to have an agreement or a settlement that is too good. So yes, Oakland could take hardline positions on any number of issues starting from day one and never move on them, and essentially force an impasse at the end of the summer. The result of that would be 800 plus pissed off faculty, which would not be conducive to running a university in any sort of collegial manner for the duration of that agreement. So that in and of itself is why Oakland would probably not do that.
Another question, which I think is an easy one. What role do non-unionized lecturers play, if any, in negotiations?
People that are not part of the bargaining unit are not discussed at the table, so they really don't play any role in negotiations. If, however, going back to a comment I made before, if Oakland intended on using many more non-unionized lecturers, and in effect reducing the number of special lecturers that were being used to teach part-time classes, then that's something that they would have to negotiate with us.
Can you speak, and I don't know if you can speak to this one, would be, because of the pandemic, the issue of returning to campus is worrisome to some folks. Is that something that is negotiable at the table? Whether
Absolutely.
or not,
Those are working conditions.
Okay.
That's a mandatory issue of bargaining. And if either side felt that this was still going to be an issue in the fall, then it has to be negotiated.
Thank you.
Mike, I have a question. Sumi.
Sure,
Uh,
sure, Sumi.
Is the bargaining team member can ask question to administration, or it has to be the chief bargaining officer?
That depends on the, how the team decides to operate. And teams decide how they're going to act the table differently. And teams that I have been on and that I have led have acted differently, sometimes differently with each issue. Typically, the chief negotiator presents a proposal. However, sometimes a team member has taken responsibility, for instance, for issues that deal with, I'll just throw a topic out, healthcare. Back in the day, Richard Pettingill from the library was always the member of the team that was the expert on healthcare. So he would be the one that would present the proposals dealing with healthcare, because he was the one that was he was most knowledgeable about every aspect of that and could answer questions from the administration just without even referring to anything. So the answer is it depends. Typically, the chief negotiator would present the proposal, ask for questions from the administration, and then sometimes it would just open up into a free fall kind of, or free flowing kind of discussion among everybody that's sitting at the table. Sometimes we have had some fun baiting members of the administration team into saying foolish things. That was kind of fun a few times ago with a certain arts and sciences dean. But that was, and that team changed their dynamics almost immediately after that session. That was kind of fun though, but it depends.
Oh,
Sumi.
because the reason I asked is, 2-3 bargaining years, you said the university lawyer didn't study the document very carefully, and he looked like a fool, and you guys caught him many times.
Well, there was the university had hired an attorney to negotiate, who a fairly well-known labor attorney in the area, and he was also negotiating several other contracts at the same time. And there was more than once when he brought the materials from another negotiation to our session. And when he needed to look something up, he would look through the materials he brought with him and realize that he brought the wrong have to run back out to his car to get the materials for Oakland. So yeah, sometimes it gets a little bit comical. And that's when Oakland goes out and hires a labor attorney to negotiate for them. These guys are extraordinarily busy and they're doing multiple contracts at a time. And yeah, sometimes you can catch them doing foolish things, not paying attention.
Thank you.
Sure.
Quick one. It's almost 1 o'clock. So who decides where bargaining physically takes place? I'm assuming this is ground rule stuff, but.
Right, that's ground rule stuff. Typically you need 3 rooms. You need a room to actually meet in that's big enough to hold both teams in a big conference room. And you need 2 breakout rooms.
And
one
this is
for the union, one for the administration.
And this is
This is
all
during
potentially
normal
different,
times.
right? Exactly. We've looked at other ground rules for
Yes.
people negotiating in Zoom where mandating that cameras stay on and whose Zoom is it? And it's like all those kinds of things are going to have to
Sure.
be determined if it's going to be.
Does it get recorded or not? Yeah,
Mhm.
there's all kinds of rules to talk about.
Laszlo, really quickly, if you find typos in the contract, send them to me or to Doug Wendell. That's the easiest. And then
Absolutely.
a follow-up question, maybe one of the last ones here, so we can get you out of here. How many members have to think something is a working condition issue before the bargaining team takes it up? I'm not sure if you can answer that, but does that make sense?
It does, but typically working conditions are pretty well defined. So if you have an issue, if there is an issue, please bring it to the attention of Amy, the bargaining team, anyone on the executive committee could forward it to them too. If there is an issue that you believe has something to do with working conditions, then that absolutely bring it to their attention.
Awesome. All right. Okay, it's 1 o'clock. I think that was really helpful, Mike. Thank you very much. I appreciate it.
Thank you.
You had a good turnout. So we'll post this up on our YouTube
Thank you.
page and eventually on our website. But thank you very much. We appreciate it.
Thank you.
Thanks everybody for showing up.